my name is Keith Barrett, founder and president of Vesta Settlements. We're doing a topical stroll through the residential real estate contract here in Virginia, and we're talking in this particular video about the Virginia Property Owners Association Act. We talked in prior videos about the fact that we have certain provisions in our contract that are really just taken right out of statute, and this is one of those provisions. So there's a statute in Virginia called the Virginia Property Owners Association Act. We essentially are cutting and pasting that statute, putting it into our contract here. Let me just briefly touch on this, give you the general overview. The seller has to make a representation about whether the property is or is not located in a development that is subject to this particular act. I'm going to casually use the term HOA, if you will, a homeowners association. So a seller represents that to the buyer in the contract. The buyer then provides in some blank lines two different addresses, a hard address, so like a property address, or an email for something that would be delivered electronically. And because this act requires a seller to order from the management company, the HOA, a disclosure statement, a property disclosure statement, and provide that to the buyer. And then this way the buyer has information upon which they can do some due diligence, look at the documentation, look at the financials, and the law provides that buyer a 3-day right to cancel under that statute, and it can be for any reason or no reason whatsoever. But once the buyer gets these documents, they have 3 days to kind of make up their mind, and if they don't do anything, deal moves forward. So this is important just in terms of due diligence and making sure that buyers are protected, that they understand that they are buying a property that is subject to this act that is in an HOA. Thanks for watching. Look out for the next video.